Because if we start labeling everybody, reputation is very important.
Yeah.
But it's important to also appreciate the perception out there. And that's what worries me as an officer in the Temple of Justice. Increasing loss of confidence by the rank and file of the populace. And justice is rooted in public confidence. And then, again, the statement you mentioned agrees with the perception in the public space. People believe that election petitions are highly transparent. And that is what those were the views echoed by late Justice Esho. So I think the challenge that we must face is not to run away from these perceptions, is to collectively agree on how to move this country forward away from these corrupt practices. What should we do? I think that's the focus of the discussion.
Yeah.
And when we are talking of corruption in the judiciary, it's a reflection of the general decay in the society as a whole. I heard you ask my senior colleague, for whom I have a lot of respect, about the meaning of corruption. And he volunteered his expert views. If I may be permitted with his permission to also add, corruption itself is derived from the Latin verb corruptus, which means a breakdown. So when there's a breakdown in institutions, it is corruption. When there's a breakdown in societal traditions, it is corruption. When there's a breakdown in ethical and moral values of the society, it is corruption. When there's a breakdown in personal behaviors, it is corruption. In fact, some people have even said there is spiritual corruption.
Which we are harvesting.
You understand me? So corruption is all embracing. I think the focus, without trying to, single out any particular institution, including the judiciary, for blame, is to insist on consequences for corruption.
We were going to go there.
Consequences.
Yes.
Certainty of punishment and severity of punishment.
Because, Mr. Shitu, how do you explain somebody admits that he misappropriated 2 billion naira and he's fined 250,000? So go in peace and spend the remaining 1.9 whatever billion.
Okay, this point is very important here now, because you look at it and say, is it about the lack of abundant knowledge of the law on the part of the judge that would, or is it basically about still the same corruption we're talking about?
I think it borders on leadership, particularly leadership by example. I'm particularly very optimistic about this administration, without any attempt at patronizing anyone, because I'm particularly very, very confident of the president because of his antecedent, and the vice president, because that I know very well, who have zero tolerance for corruption. And so with leadership, if the leadership is prepared to lead from the front, you can see that a lot of people now are beginning to change their ways because they now know that a new sheriff is in town.
Yes, that's true.
It's important. So leadership is, and even the judiciary itself, under the proactive leadership of the current Chief Justice of the Federation, will turn a new leaf.
Because
now,
if
Mr.
you
Johnson,
say it's about leadership,
yes,
maybe Mr. Johnson can also talk about this. If you say it's about leadership, I raise the issue of whether there is also some kind of inadequate knowledge of the law. Because if a judge that is supposed to know all would give such judgment, for instance, in this case, as mentioned, how do we see this and say, okay,
how does he arrive at that figure?
Indeed, he had the knowledge of the law.
All right.
It's not about knowledge, because you talked about consequences. And I will tell you the inadequacy of consequences factor in determining or fighting corruption. If the law provides that any man who steals, irrespective of the quantum of the amount,
stolen,
yes, shall be guilty of an offense and sentenced to a maximum of 2 years. So if the man stole 10 naira
2 years,
and you found him guilty, it's 2 years.
the man stole
If he
2
stole
2 billion.
not even 2 billion, the whole of Nigeria,
It will still be 2 years.
it's 2 years.
So are we saying we should go back to the Constitution?
All right, now going back to the Constitution, my take is that it's not all about consequences. It should start from setting standards. Now, from what my two colleagues have said, I pick something, and it takes me back to what I have advocated over and again, that when you set standards, you now start looking for who has breached or run foul of standards set. Let me give you one practical example. If a case lasts in the court, in our Supreme Court, for example, for 6 years, 8 years, the client is getting anxious. He wants to get justice. He can't wait for 6 years. And it is indeed very unreasonable for a case to be in court for 6 years. I call the justice dispensed at that level as graveyard justice. When somebody has spent about 2, 3, 4, 5 years at the High Court, then maybe 4 years at the Court of Appeal, then 10 years. I mean, the man is getting close to his grave. So what you now find is that somebody somewhere will come up to say, oh, I had the wherewithal to get a date for you to be had. Right or wrong, because I have seen cases where even people who don't have the connection to get a date, they come out to say, we can get a date for you. And then they
ask for...
Exactly.
Oh, God.
So if you set a standard, for example, that once your case comes in here and your papers are in order, within 2 years you must be heard. Why should I start looking for somebody to lobby to help me do 1 or 2 things and begin to collect bribe and all that? So these are some factors that, you know, make corruption in the system very attractive. For example, there are cases where you see, like I have mentioned somewhere, we have some classes of lawyers these days. There are some lawyers whose practice is just to go around and lobby clients, snatch clients away from you, because you are not doing it fast, you know, such things. Now, it is because the system allows such a delay that somebody will spring up from nowhere and want to snatch your client or your brief from you, which is corruption.
It is corruption.
All right. So if we go back to setting standard first, before we talk of consequences, you find that we'll be moving some steps forward.
Now, Malaki, interlocutory injunctions play an important part in this matter. Can you please explain to us exactly what they are?
And some people have said this is like some kind of loophole in the judiciary where every lawyer would try to exploit.
Interim, interlocutory, perpetual injunctions.
Perpetual.
Yes.
Peter Odili.
Thank God you had the temerity to mention that. These are all restraining orders by the court to stop or prevent the happening of something. You don't invoke them when that thing had already happened. Now, it causes worry, no doubt. And if you want to be charitable to the same judiciary we are castigating, you will find that they've also taken very strident position on that. Most judges get sanctions these days, particularly in recent times, when such injunctions are arbitrarily ordered or awarded. The beauty of the judiciary too is that it is a self-regulatory body. You probably have heard of the National Judicial Council. This is the body in the judicial system that has a capacity to discipline the judicial officers. And they've been doing quite a number of things in recent times.